Hello and welcome to tutorial key point video number 2. In our session, first of all, we looked at statutory interpretation, and there are 3 questions that you need to think about. Firstly, what are the problems in discerning Parliament's will? Secondly, do judges make law? Thirdly, should judges make law? We looked at the tools for interpretation. Again, it's important that you understand what falls into each category and to be able to explain what they are. The rules of construction, the literal rule, the golden rule, the mischief rule, and the purposive approach. The rules of language. Now, some of those are written in Latin, but you're not going to have to memorize those as long as you can explain them in English. Aids to interpretation, what can be used, and compare and contrast the different aids, and the presumptions. Then we moved on to judicial precedent, and what you need to be able to do is to be able to explain the basic rules and the tools that are available, and in what circumstances a previous decision isn't followed. The best way of getting used to this is by looking at full law reports, which you can get through the Open University library, through Lexis or Westlaw, and read the judge's reasoning. And you'll start over time to get used to those things which look as if they are the ratio and those that are clearly obiter. We looked at English legal system, and I stressed the importance of knowing the basic hierarchy of the courts, the personnel, and in particular the role of lay people, magistrates and juries in the legal system. I then briefly introduced the principles of UK constitutional law, 3 in particular: the separation of powers, where that doctrine's come from and what it's meant to achieve; parliamentary sovereignty, and here Dicey comes in useful because he puts it down as 3 propositions. Firstly, that Parliament can pass any law it wants. Secondly, no Parliament is bound by its predecessors, which is actually turning Dicey on his head, but giving a perspective which I think is more understandable. And thirdly, that no court can question what Parliament has done. And then conventions, not meetings held prior to writing a constitution, but non-legally binding rules, not enforceable in the courts, but which the leading constitutional actors regard themselves as bound by. We discussed ETMA 01, and have a look at the last tutorial on ETMA 01. I said basically the same thing. You need to go through, define, evaluate, and look at the criminal and civil liability in all those circumstances. ETMA 2 is a long way away, but as you're doing your reading, think about explaining what statutory interpretation is, the need for statutory interpretation, explain and evaluate the traditional rules, and discuss the relationship between the rules. Remember, at degree level now, you need to be concentrating on the critical evaluation rather than just describing what somebody says the rules are. So consider the need, evaluate whether they're rules at all, and the usefulness, and how much it gives judges the freedom to interpret. Discuss other aids to interpretation, and as a conclusion to your argument, not a restatement of what you said, but as a conclusion to your argument, finish it off. No need for a long introduction which says what you're going to say, then say it, and then summarize by saying what you said. That way you'll just use up the word limit and not get any marks for that. So, look forward to seeing you at the next tutorial. Bye.